Everyone, welcome to the disability Facebook stream. My name is Sivan Tumarkin, and I am a co-founding partner of Samfiru Tumarkin. We help people with long-term and short-term disability claims across the country. We have physical offices in various provinces: Ontario, BC, Alberta. We recently started an office in Saskatchewan, and so we help people with their long-term disability questions, with any issues you're having with your insurance company. No question is stupid. It doesn't cost anything to get this information. And my goal here today, over the next 30 minutes, is to make sure I answer your questions, to make sure that I educate you as much as possible, arm you with information when you deal with insurance companies. I've had several decades worth of experience. Many of our lawyers have worked for insurance companies. I've worked for insurance companies in the past. So it's really important to understand what your legal rights are, because insurance companies, despite the fact that they look like they are omnipotent and they have unlimited power, they don't. They're actually very, very vulnerable. And in a way, it's a mirage. Let's start off with some typical types of questions and issues that I face and I get many emails about and many phone calls about. And one of those things is the 2-year mark. And to answer that question, the 2-year mark, the change of definition date, for some people here who are listening, who are tuning in, you may not be aware of this. You may not have gotten to that point yet, or you may have, and you have questions. So let me talk about this in larger context. Number one, when you apply for long-term disability, you are applying because you can't work. You can't work because of an injury or illness or a combination of both. Okay, I've seen all kinds. It could be a degenerative muscular disease, neurological issue, car accident, any number of issues, stresses because of the tariff, stresses because of family circumstances. For whatever reason, you cannot work. And so you go ahead and you apply for disability. Let's say you go on sick leave and get government unemployment insurance, or let's say you have shortened disability. Whatever happens, you're now in a position where you want to apply for long-term disability. To get long-term disability, you have to demonstrate to the insurer, you have to fill it out on the application, that you cannot work or you cannot perform the essential tasks of your own occupation. This is called the own occupation test. Very, very important. The question is, are you disabled? And the insurance companies in their policies, they use the phrase total disability, totally disabled. It's misleading. I'll explain why. But they say, are you totally disabled from working? And again, the question is, not are you totally disabled in layman's terms, meaning not are you brain dead or are you quadriplegic, God forbid, or you can't get out of bed. The question really is, are you unable to perform the essential tasks of your job, of your employment? If the answer is yes, and if your doctor or doctors confirm that in fact you need time off to recuperate, to undergo treatments, whatever the issue is, if your doctors confirm this, that means that you should be able to get long-term disability. You should be able to clear that hurdle of that test, that initial test. Now, many people are rejected at that point, and we help them out. We help them with insurance companies. We force the insurance company to either approve them or to pay them a settlement. But some people are approved for that initial disability period. And so people ask me, how long does that period usually last? Typically, under most long-term disability policies, that own occupation test, the own occupation period is 2 years. 2 years from the date that you have been approved. Okay. So what happens at the 2-year mark? Well, first of all, it doesn't actually happen at the 2-year mark. It happens before. But what happens at the 2-year mark? The 2-year mark, the test changes. The test to qualify for long-term disability beyond 2 years of being on LTD changes. No longer is it the question of, can you perform the essential tasks of your own occupation? The question is, can you perform the essential tasks of any occupation for which you are suited for by training, education, or experience? Okay, very important. Training, education, or experience. So it's a broader test. Now you got to show that you can't do any type of job or employment for which you're suited for. Not any, but any for which you're suited for. And that's where many insurance companies cut people off. And I say that they start the process before the 2-year mark because you'll start getting phone calls and letters and emails from your adjuster saying, well, what kind of other jobs can you do? Or maybe we should start a return to work program. Or maybe we should have you seen by one of our doctors for an independent medical examination. I put that in quotes because it's not independent. It's somebody they hire to assess you. So the 2-year mark is important because many people get cut off at that point. Many people's benefits stop, and they think that they're not entitled to any more benefits when in fact they are, because they cannot work in any other occupation for which they're suited. I can tell you those kinds of claims are very, very strong claims. If your doctor says that you remain unable to work really in any other job for which you are suited for. If your doctor says that, the insurance company must pay you. Insurance companies, again, being insurance companies, are playing the odds. They're playing the odds that you're going to give up and walk away, that they're going to tell you there's no point. Now, what they do when they deny your claim, they tell you that you have the ability to appeal that denial. And I want to talk about appeals because we have a question here from Facebook. We have from Donna, who says, I recently hired a lawyer to help me file an appeal for my LTD claim. After submitting everything with my lawyer, my claim was still rejected, and I'm not sure where to go from here. So this is really, really important. And it's really, really important because I often tell people, look, I will never say to you that appeals never work, but I'll never also tell you that playing the lottery never works. Sometimes you can win. Well, I can tell you that in my experience, it's very rare for these appeals to work. Why? Because you're essentially re-asking the same company, the insurance company, to approve you again. Now, what do? They say, okay, well, give us more information, give us more documentation to consider. So you go to your doctor, you go to whoever you want, you get more reports, only to have the insurance company drag the process out and reject your appeal again and again and again. In the meantime, you're frustrated. The bills are piling up high. You have no idea what to do. So these appeals are typically useless, in my opinion. If you want to appeal and you're insistent on it, we will help you for free. We will help you, okay? We'll tell you how we think you can strengthen your appeal. But the reality is, it doesn't really matter what we do or you do, because insurance companies are insurance companies and they care about profit. That's really the key. And so I tell you now that there's a much more effective way of going about this. And the effective way is a legal claim. And I'm not saying this because I'm a lawyer. I'm saying this because this is through experience. Whether it's through me, through my team, through a different lawyer, if you initiate a legal claim for wrongfully terminated or denied long-term disability benefits, your chances of resolving the claim with the insurance company shoots way up. You know why? I'll tell you. Because now an insurance company, now your file within the insurance company complex goes from the adjuster that was handling your claim to the litigation department. And now they have to rely on a lawyer, either works in-house or that they have to hire to fight this claim. You know what insurance companies hate more than paying legitimate claims? They hate paying their lawyers to fight legitimate claims. I know, because I used to be one. And insurance companies, my adjusters would call me up and say, Sivan, when are you settling this case? You know, we don't want to keep paying you and paying you and paying you. They'll never tell you that. But that's why starting that legal claim gives you so much leverage with the insurance company. So keep in mind, if you are rejected for long-term disability benefits, or you're denied any point throughout the process, or your benefits stop, don't play that game with the insurance company of appealing, okay? At least contact us first before you consider even doing that, or consider doing anything, because we can assess your claim. We can tell you what your chances are of doing this or doing that, how to strengthen your claim, etc. Okay, we have another question here. If you have a progressive illness, what is the likelihood that you can get LTD when things progress to a point where you can't work? I can tell you that your chances are, likelihood, should be very high. And it should be very high because progressive illnesses, whether they're neurological, muscular, cognitive, whatever those are, typically you're going to be treated by various specialists, whether it's a neurologist or a rheumatologist or physiatrist, whoever it is, whatever the illness is, you're going to have a specialist. You're going to have still a family doctor, presumably. I would assume that your specialists are going to back you up and say, this person cannot work. You know, this individual needs time off, whether it's forever or whether it's just for the foreseeable future, whatever. The insurance company is going to be faced with medical opinions of treating specialists who are saying that this person is having a progressive condition and they must stop working. And if that happens, the insurance company should appeal you. And I say should because, again, sometimes they find excuses not to. And this is when we go after them. We go after them and we fight them on this. And, I tell people it doesn't cost anything, first of all, to get the information from us. So we can tell you if you're rejected or they don't want to, or they not giving you an answer. Sometimes the insurance company just says, we want more and more documentation, but they're not giving you a decision. Again, they can drag out the process forever. I usually tell people, if you've submitted your documentation, your application, and the insurance company is not giving you a decision, they keep asking for documents, and you feel you've given them everything, then give them a deadline. Say, if I don't get a decision within 2 weeks, give them a date and a time. Say, I will take that to mean a no, a rejection, and then I'm going to consult an LTD lawyer. Give them my name even. Tell them you're going to consult me, you're going to talk to me. I know all these insurance companies. I know many of these adjusters. So it's very, very important that you understand that you have a lot of power here, a lot of power when it comes to insurance companies. Question from Serena. When your insurer asks you if you can perform any job, is there a guideline for what kind of occupation they say you can do? Yeah, it's an interesting question. I'll tell you kind of how we approach this. So remember what I said, that at the 2-year mark, the test for disability for getting LTD changes. No longer is it, can you do your job or your occupation? It's, can you do any occupation? But most people, and frankly, insurance companies too, forget the other part of that test. Not can you do any occupation, period. Can you do any occupation for which you are suited for by training, education, or experience? So if you are, I don't know, a computer programmer and you've done that for 20 years, haven't done anything else, and suddenly the insurance company says, well, we know you can't do that, but we want you to work as a chef. I'm just throwing out hypothetical. It doesn't work that way. I mean, typically what we see people who have either sedentary jobs or types of jobs that say that, maybe you have transferable skills, and the insurance company may even send you to an assessment to try and get a list of occupations that they think you can do. You look at that list and you're like, I can't do that. I don't know anything about this. I don't know how to do this or that. I have no education. I have no experience. I have no training. Then the insurance company is simply barking up the wrong tree. Okay. Now, there is another way that we look at to see whether or not you are, or you should qualify or are able to qualify for any other occupation. We look at commensurate income. Just think about it this way. When you apply for long-term disability, under most policies, your LTD insurer pays you around anywhere from 60 to 75% of your pre-disability income. The majority of LTD policies are around 67%, 2/3 of your income. At the 2-year mark, if you can do another job, another occupation that will pay you that amount, that 67% or whatever the amount is that the insurance company is paying you, that's a litmus test. That tells me that you may not qualify for LTD. But the majority of people who contact me, they tell me, look, I can't. Maybe I can do a few hours a week here and there, but there's no way that I can earn commensurate income, that 2/3 of my salary, of my pre-disability salary. I can't, given my psychological issues or physical or neurological, whatever. And so that's how you look at this. It's from two angles. Number one, can you perform any other job, any occupation that you have training, education, or experience in? Number one. And number two, can you earn in that occupation commensurate income, i.e., let's say 2/3, 60, 65, 70% of your pre-disability income? The answer is no to either of these questions. You should continue to qualify for LTD. You should pass that 2-year mark. The insurance company should continue paying you. Again, many insurance companies do not, and they give you a whole bunch of excuses. I've seen this time and time again. I don't call these reasons. I call these excuses. And we hit them back. When we start the legal claim, first of all, we get their file, so we can see everything. We see the guts of how they made their decisions. They're obligated to give that to us by law. You can't do that with an appeal. You can't do that if you don't start the legal claim. It's the legal process that now triggers certain obligations that they have to you/us to give us their file, and then we can go through it and then hit them where it hurts and go after them and really point out all their mistakes and then force them to the table. Because the reality is, if they don't come to the table and negotiate in good faith and settle for what we think your claim is worth, well, then a judge is going to make a decision here. And trust me, insurance companies hate going in front of a judge. They hate it, okay? The optics don't look good. Injured person, disabled person, big insurance company. Doesn't look good. Okay, let's continue on here. Okay, I have a question here about WorkSafe BC. So that's like workers' compensation. We don't deal with workers' compensation, but Bruno, if you can reach out to me after the Facebook Live and I'll point you in the right direction. There is a law firm in BC that specializes in workplace safety issues. We deal with them a lot, and I can refer you to them and make sure that you're in good hands with them. Derek writes, I understand you deal with claims based on when you're working, but what if you were a caregiver to a parent and not working for 2 years, and then you need to apply for SCD LTD based on non-work injury? And a follow-up question from Derek, I guess I'm saying, do you deal with the government instead of just insurance companies? It's a good question, Derek. Government obviously does provide disability programs. For example, in Ontario, you have the Ontario Disability Program. We also have a federal program, which is called CPP Disability, not CPP Pension, but disability. We deal with CPP disability. We don't deal with other types of governmental programs. Those are just different. Typically, legal aid in whatever area you're at, from wherever it is that you're calling us or writing us from, they typically deal with these kinds of issues. You can also go on the Law Society, again, wherever you are, Ontario, BC, any province. The Law Society typically also have a referral service for these kinds of claims. So you can find somebody that can help you with a government disability program if you get denied or if you need help. But we don't deal with those except for CPP disability. They're just a different thing. It's like workers' compensation. We deal with insurance companies. We deal with these entities which are megalithic companies that seem to think they can do whatever they want. And with us, they just hit a wall. They can't. Brianna writes here, my sister is on disability. She's worried that she's being surveilled. Okay, surveillance. How likely is it? She should be worried. It's causing her a lot of anxiety. Okay, I understand completely. Why that would cause her anxiety. So keep in mind, insurance companies do surveillance regularly, not on every claim, not all the time. They're entitled to do it up to a certain point. For example, they cannot interact with you if they're surveilling you. They cannot walk into a personal space. They cannot interfere with your life. However, they are allowed to video you. They are allowed to photograph you from afar. And typically when an insurance company tries to do that, they're trying to find something that is inconsistent with something you've said to them or that your doctors have said. For instance, you say, I always walk with a cane. I never, ever not walk with a cane because of my injury. And then they do surveillance and they see that you're not walking with a cane. In fact, not only not walking with a cane, you're playing soccer in the field. Well, that's a problem. But typically I tell people, look, if you're being honest, if you're disabled, let's say your disability is from psychological issues, depression as an example, okay, that can be debilitating. You're not sleeping, you're anxious, you have issues. But you know what? Every day you take your kid, you walk your kid to school, and the insurance company surveys you and sees you doing that. So the surveillance soundly shows you're doing something. It doesn't contradict the fact that you're disabled because of depression and can't work. It's very, very different to work for 8 hours or more at your job and taking your kid to school in the morning. But the adjuster may see it differently, and the insurance company may send you a letter saying, aha, we caught you. We know that you are not disabled, that you are lying because you can do X, Y, and Z. And what I find in many cases with surveillance is that it's a method of gaslighting the individual. And it works particularly well and effective, unfortunately, with people who are experiencing mental health issues, or if they have anxiety or depression or phobias. It really, really triggers these things. You cannot stop the insurance company from doing it, but I can tell you right now, in the vast majority of cases, this surveillance is completely ineffective. When I used to work for insurance companies many, many, many years ago, I ordered surveillance myself on some claimants. And I can tell you, for the most part, surveillance is very expensive. Back 20 years ago, it cost insurance companies about $1,000 a day to get a private investigator to do surveillance. It must be more now. Do you really think insurance companies want to waste that money? So even if they are doing surveillance, maybe they'll do it 1, 2, 3 days. Maybe they'll do it, over a long weekend and maybe another long weekend. But it's not a situation where there's a car parked outside, your house, and for the last week or two, people are just watching you. Maybe that's happening, but it's not the insurance company. I can tell you that. It's too expensive for them. Okay, they have budgets. So I wouldn't be worried about surveillance if you are being truthful. And so for Brianna, I would tell you, if your sister is truthful with the insurance company, if she's reported everything that is happening to her, if her doctors are being truthful, she has nothing to worry about. And I'll tell you, if the insurance company raises a stink or says something or tries to gaslight her, tell her to call me, or you call me immediately with her permission. I'll chat with you. I'll explain things. If you get a letter, if she gets a letter, I'm happy to look at it. Again, it doesn't cost anything. I mean, unless you hire us and we get money for you from the insurance company, of which we take a percentage like a real estate agent, it doesn't cost anything to get this information. I don't care if you email me 5,000 times. I have people I've been helping out for years now, just by email and text. So it doesn't cost anything. So even if your sister, Brianna, wants to speak with me or a member of my team, again, no charge, and we can calm her down and we can help her with her questions, feel free to connect her with me, okay? Our information is going to be on the live stream here, and it's going to be after the show as well. Feel free to reach out to us. Again, we will help and we will answer all the questions. Okay, I have here another question here, which is from Dwayne. What should we know about frustration of contract while on LTD? Okay, so that's an employment question. One of the reasons why we do these Facebook Lives is because it's also an opportunity for us to explain that at our firm, we have kind of a unique specialty, which is a dual specialty: disability / injury claims and employment. In fact, most of our lawyers at the firm are employment lawyers. They specialize in employment issues. Frustration of contract is an employment concept. I'm not an employment lawyer. I will touch on it briefly, but I can tell you that we're going to have a Facebook Live that is going to be coming up, and that's something that you can certainly ask, or you can just reach out. There's a lot of resources that we have, and we can help you with that. But really briefly, kind of top level, frustration of contract happens when the employer says, look, you've been on disability, or we've been away from work for quite a while. We don't have a job for you anymore. Well, that's a problem on multiple levels. Number one, if you've been fired, you are potentially owed severance. So we can help you with that, okay? That's something our employment lawyers can help you assess and tell you if, in fact, the employer is correct or if, in fact, you're owed money, number one. Number two, firing a person on disability is a human rights violation. It is contrary to the Human Rights Code. I'm not an employment lawyer, but I've heard a lot from my employment colleagues who will tell me this repeatedly, that they have employers that they're seeing who are firing people who are disabled. Big no-no, big problem, okay? So when you're dealing with a frustration of contract, you need to get that legal advice. And the reason why I mentioned that we have a dual specialty is because there is an interaction between employment law and disability law. And again, I'll touch on this very quickly because we have other questions I want to get to. In disability policies, LTD policies, there's usually a provision that states that if you get severance from your employer, we, the insurance company that are paying you LTD benefits, we're entitled to a credit for whatever you got for severance, because you shouldn't be getting LTD payments, which are income replacement benefits. Effectively, they're replacing your income because you can't work, at the same time for which your severance is supposed to cover. You can't get severance and LTD for the same time period. It means you're being enriched. You're getting more than you otherwise would have had you not been disabled. So we, at our firm, because we work together, employment lawyers and disability lawyers, we figure out how to maximize the chances or the possibility of you keeping as much of that money that you're getting from your severance in your pocket, and not have the insurance company that's paying you LTD eat it up, gobble it up. I have had people contact me who have dealt only with employment lawyers who had no LTD experience. They got their severance only to be waking up to a very rude surprise that the insurance company says, oh, it's great that you got severance worth of 6 months of employment income. Now we're not paying you LTD for those 6 months plus. So very, very important to understand that, frustration of contract is an employment issue, but the consequences of dealing with it, if you get severance, could affect your LTD. And so this is why I'd love to speak with you after the Facebook Live, and certainly kind of understand a bit more and put you in touch with one of our employment lawyers. We also have lawyers that are hybrid lawyers. They do both employment and LTD. And we have them with dual specialties exactly for this kind of a reason. So we can help you with that. A question from Vula. I've been dealing with a toxic work environment with a lot of bullying. It set me back a lot as I have worked hard to get past this. If I have to go on LTD due to mental distress, would disqualify. I've had a rough childhood, which has left me with some mental health struggles. Okay. Excellent question. So first of all, I'm very, very sorry that you're going through this, Vula. The important thing to understand here, and this is really, really important, is that LTD insurance is not bad work environment insurance. Meaning, if your work environment is toxic and it's creating a problem for you psychologically, that you can't work because of it, we have to understand exactly what has happened and where you are now in the process, and I'll explain why. If I spoke to you directly, I would ask you, Vula, okay, if we put you in a different work environment now, are you able to function in a different work environment? If the answer is yes, it's simply here that you're having issues. But if you change work environments, doing the same job, you'd be okay. You have now an employment issue. You have an issue that one of our employment lawyers can help you with, specifically dealing with a toxic work environment. Toxic work environment, which means you may be able to claim constructive dismissal for being essentially unable to work because of this toxic work environment. But if I were to put you in a different work environment and you're unable to function because of what's happened here, in other words, what's happened in your current work environment has impacted you to such a level that now it doesn't matter where you are, you simply cannot, for the foreseeable future, work, no matter where. Well, now we call that a generalized condition. It kind of blossomed out, unfortunately, and now you should qualify for LTD. Now, the insurance company is still going to tell you it's an employment issue. They do this all the time. But again, this is why I'm saying, if we put you in a different work environment, can you work? And if the answer is no, I can't, well, guess what? The insurance company is going to have to pay. We've dealt with many of these cases. We've resolved many of these cases with large settlements from the insurance companies. Okay. Question. I am on a medical leave due to severe depression and anxiety. My healthcare provider has filled out the required forms, but this was denied by my employer, an Ontario hospital, due to insufficient information. My HCP then wrote a letter detailing my diagnosis and treatment plan. Again, I was denied. My doctor then contacted the head of occupational health, who basically stated no matter what she could provide, I would be denied. Wow. My doctor has told me to reach out to HR as she has never experienced this level of pushback. Is there anything I can do? Okay. So two issues here, two questions. Number one, are you unionized? Because if you're unionized and it's the hospital that is paying, the hospital that's the one that's paying the LTD, you may have to go through your union, okay? But if you're dealing with an insurance company, even if you're unionized, we may be able to help. Not in every case, but in many unionized settings, we can. To answer your question substantively, okay? If you are unable to work due to severe depression, anxiety, and that's been recognized by courts, okay, as being a legitimate reason not to be able to work, and your doctors confirm that you cannot work, there's no way in the world that an insurance company can maintain a denial like this. I mean, they could try, but we would steamroll them. And again, I explain this in this way. If we ever went to court, and we almost never do on these kinds of cases because insurance companies are terrified of going to court. But if we ever went to court and your doctors and you testified, again, not saying it's going to happen, but just play the game with me. What do you think a judge is going to do? Do you think a judge is going to simply stand there and say, oh, yeah, no, insurance company, we agree with you. We're going to ignore what the person's saying. We're going to ignore what their doctors are saying. We're going to ignore what their specialists are saying. Of course not. The judge is going to hit the insurance company over the head. And we have cases where judges not only have forced insurance companies to pay these benefits, but also awarded punitive damages, punishment against the insurance company for acting in such a high-handed manner. So do not be afraid, but I don't have enough information about your situation here in terms of whether you're unionized, who's paying for the insurance. Feel free to reach out to me again and we'll connect, whether it's me, somebody on my team, but we'll connect and we'll figure out what the answer is to your question to give it to you. And if you need any help and we can offer it, by all means, we will offer it. I love nothing more than going after these massive entities, these insurance companies, and forcing them to pay. It is a pleasure to do that. Trust me, we get off on that kind of stuff. This is great. Okay, we have another question here. BC Pinoy, I'm 53 years old. When is the best time to accept a lump sum payment from LTD insurance? Pros and cons. Ooh, we're just about to wrap up here. But I'd love to speak with you a bit more about this. Please contact me after the Facebook Live. But let me just spend 1 minute answering this really quickly before we move on. Lump sum settlements is when the insurance company says, you're on claim, but we would like to offer you this handsome settlement that is, really a chunk of money. But in exchange, we stop paying you forever. In other words, we cut the umbilical cord between us and you. That's it. I'll tell you this. It's rare for me to see fair lump sum settlements. And the reason is simple. The insurance company is offering you that because they want to settle your case for cents on the dollar. That's the reason. Now, does it make sense sometimes? Sure, it depends on your personal circumstances. But I can tell you, in the vast majority of cases, if you were to take the amount they're offering you, if you think you're going to continue being disabled for a long time, maybe to age 65 potentially, do the math how much you are foregoing in exchange for the amount they're offering you. I've seen cases where they're offering somebody $100,000, but if the person stayed on LTD till 65, the claim is actually worth about $600,000. So they're getting 1/6 of whatever the value is. So again, it depends. It's your decision, and we often advise people on that. Often the insurance company doesn't want to negotiate the lump sum. That's the other thing that we found. But I tell people, look, if you're legitimately disabled and you think it's going to be for the long term, I would not settle unless there's a very good reason. I would not settle for a lump sum. But again, every case is different, so we can certainly chat about that. Again, doesn't cost anything. Have a chat about this, about your situation, and see what we can do to to make sure that you're comfortable with whatever decision you make. Okay, that's all the time we have. I'm sorry. Hopefully you enjoyed today's session. Make sure that you share this video, you subscribe to this channel for future live streams. We do as much as we can to educate the public, to empower you, to tilt the board in your favor against insurance companies, not just even the playing field, but to tilt it in your favor. We're going to have an employment law Q&A on Thursday. Okay, so that's tomorrow, May 1st at 2 p.m. Eastern Time with Jeremy Herman, one of the great lawyers in our firm that is just spectacular in employment law. So please tune in, and hope you have a great day and a wonderful week, and I will see you soon.